We will reconvene. Now, is Mr. Gunderson available? Oh, okay.
Two bells at 11:12 a.m. Advise members they have 15 minutes to record their vote on the Abercrombie motion.
Yeah.
This is a 15-minute recorded vote on the motion.
It's going to be one of those days. We just got called back to vote. But let's ask some questions anyway. Let's have a little conversation. Mr. Schwatka, in your prepared testimony, you say that TSA's use of AMS, quote, acts as a market limiting factor for those firms who do not have the resources to master and navigate through the multiple systems, unquote. Can you explain what you mean by that and tell me how that impacts small and disadvantaged businesses?
I'd be happy to, Mr. Chairman. Thank you. As we've talked earlier today, the federal government's procurement system, as you know, is a rule-based system. It contracts act and set the terms and conditions between the government, who acts as a purchaser, actually the buyer, and the private sector, who offers acts as the seller. And so what this separate but unequal system provides is increased cost to learning, as we talked about, the increased compliance cost, added barriers of knowledge because of those rules and the inconsistencies between the AMS and others in the procurement area. There are really three types of companies that are out there: those that are already doing business with the TSA and have either mastered the rules or felt comfortable with them; those that are already government contractors somewhere else and know the FAR a little bit but don't know the AMS system and can maybe think they can learn that; and those that are not government contractors today who don't know anything about even the government-wide system and find this very daunting. And so when you tell people that there are really several systems, if you want to do business only with TSA, you can learn one rule, but if you have any interest in doing business elsewhere in the government, that multiple systems really presents a daunting task, particularly for small businesses. It's a cost, it's a compliance, it's a knowledge base, all three of those factors.
I'd like to return back to the conversation we were having before we broke to go vote. We were talking about some of the issues. I think you just addressed them, Mr. Schwatka, but Mr. Bonheimer, do you care to re-engage on that discussion we were having?
Thank you. With respect to the difficulties of trying to comply with two sets of rules.
Correct, yes.
One of the most sophisticated contractors that I deal with, and one of the attorneys with the most experience in the business, was commenting on the challenges of trying to follow not only the TSA clauses, which are somewhat different from some of the FAA clauses, which are different from the FAR clauses. And when you put them all together, it becomes an alphabet soup of trying to figure out what clauses am I complying with today. That was very persuasive to me when somebody with that level of sophistication and experience said what a challenge it is trying to comply with these multiple sets of clauses. He said he was old enough, he would like to have one rule.
Understood. Ms. Duke, I'm trying to understand the justification for having only TSA under AMS. What is different or special about TSA that only it should be exempt from the FAR?
I actually, there is nothing currently that I think TSA was stood up with AMS and it was given that authority at the beginning, and we have not asked for that authority for the rest of the department, but there is nothing specifically unique about TSA. It is nice for TSA to have that flexibility of authority because it does give some good flexibilities in the procedures for TSA. So really, it was given it, and it's a matter of there's not been a discussion of giving it to the rest of the department, but rather taking it away from TSA.
Are you then sort of advocating because of the flexibility issue that AMS be extended to the rest of the department? If not, why not?
I think there are benefits to AMS. With a qualified workforce, it allows the contracting officers to make good judgment calls. It allows them to have more open discussions with industry. And it allows, I think, for really better business deals, a more closer meeting of the minds at the time the contract's signed. At this point, we're not arguing for it for the department. I would say principally because with all the procurement and acquisition legislation going on, it really doesn't seem like one that would be entertained with any earnest. And I guess it's a matter of picking the battles.
Well, we get to pick the battles here.
Yes.
All right. Yeah, it's. I mean, just from the outside, somebody just kind of looking at it, it doesn't quite jive. Why would you have that? Or if you're so sold on it, why would you not advocate that it be spread throughout the entire department? And in fact, indeed, the government. Does FAR not give you the flexibility you need? Is that the issue?
I think for us, Mr. Chairman, it's a maturity issue. It's right now we're developing the basics of our workforce, and I think to appropriately use the flexibilities and the judgments that AMS gives, that as we grow the maturity of our workforce, we'd be better positioned to use that overall as a department. And so that would be principally why I'm not arguing for it now, is I really think that with the flexibilities comes responsibilities, and I would like to grow our workforce and make sure they have the basic competencies before I advocate for those additional flexibilities and authorities.
Okay, we'll come back to that. Mr. Schwatkin, in your testimony, you state that you can, quote, say with confidence that bringing TSA at least under the common rules applicable to the Department of Homeland Security will increase competition, expand opportunities for greater small business participation, provide greater accountability and transparency in their procurement processes, and provide greater options for addressing the challenges of the department's acquisition workforce, unquote. Can you tell us, expand on that, and tell us the basis of that belief, please?
Yes, sir. Many of our member companies, and we've had the opportunity to participate in broad procurement fairs with members of Congress and hosted by Professional Services Council. The companies tell us that their understandings, that when they put systems in place, they want them to apply government-wide. They want to address those issues on a government-wide basis. We comment frequently on rules and regulations and on legislation that move us farther and farther away from that uniform set of regulations. And so as we've talked before, from a cost standpoint, from a compliance standpoint, and from an education standpoint, all of these factors tend to drive people away from a marketplace that they don't know whether they can be successful from the company standpoint. Couple that with an acquisition system where there is no predictability and consistency, and there's no way for companies to know that they can be successful. They will husband their resources carefully and go look for opportunities where their chances of success are greater.
Thank you. Thank you. Mr. Bonheimer, can you describe the FAR process for resolving protests and disputes and compare it to the AMS process, please?
I'd be glad to, Mr. Chairman. The technology is obviously overwhelming to me. I'd be glad to answer the question. With respect to the difference between the two processes, certainly the TSA protest process has experienced people, well-respected people who hear the disputes and the protest and make the decisions. However, when you compare that to GAO, GAO has over 80 years in deciding protest, has thousands of precedents that tell you what the rules are, and they have unquestioned independence. So if we gave a choice to the companies I talk with, would you rather use the TSA protest process or the GAO protest process? They would almost uniformly pick the GAO protest process. In addition, the GAO protest process has certain teeth that come with it, such as the stay of performance, protest cost. And finally, the last thing I like to add, as a Navy attorney, one of the things that really got my attention were GAO protests and the concern about getting one. So with that hanging over my head, we tried to build the quality in up front in the procurement process so we wouldn't have that later.
Between the two processes, the FAR and the AMS, which do you think private industry prefers?
My understanding is they would like to have one system, which would be the FAR system that works, particularly the competition component.
Okay. Anybody else care to comment on that question?
I would concur. That's been the experience from our member companies.
Thank you. Ms. Duke? Mr. Gunderson? Okay. I have to go
Chairman,
vote. Yes.
If I could just make one comment on that. When you look at the industry base that we deal with, these companies deal business not only with the federal government, but they're dealing business in the commercial world as well as with states. So these firms are used to dealing in multiple environments. So for them to be able to adapt to an AMS environment, I do not see that as a significant lift.
Could you elaborate why?
As I've addressed before, again, the fundamental tenets are the same. And while I recognize that there are some differences in maybe how the clauses are worded from the FAR, the tenets are the same. We have, over the past 5-6 years, spent about $2.5 billion a year dealing with large firms and small firms. We've had an open dialogue. We engage with them before we issue solicitations, through the solicitation process, providing every opportunity for them to express a concern, ask a question, receive guidance on how to deal with our system. I have not had one person address me to say that they've had an issue with this. So I think that open dialogue has provided them an opportunity to say that AAMS is causing them problems, and I have not seen it.
I understand. But it seems to me if the tenets are the same and we're not in an emergency environment any longer, having duplicative systems, well, is duplicating effort. In any event, I am going to go vote, and I will adjourn this hearing for the day. I appreciate all of your testimony, and I imagine there will be questions that you will be asked to submit in writing. Please do so promptly, and we appreciate you showing up today. The committee stands adjourned.